Hello, welcome. This is the Standing Committee on Health and Social Development. Today is Wednesday, February 17th, and this is the 9 o'clock meeting. So welcome members here today, and we're just getting started. Could I get a motion to adopt the agenda? Corey Deagle. So this morning we're going to have a briefing and briefing on challenges in the area's opportunities with respect to information and protection of privacy and other matters. And I will pass it over to our guest. She can introduce herself for Hansard and then begin with her opening remarks, and we'll go from there.
Good morning, Chair and honorable committee members. My name is Denise Doiron. I am the current Information Privacy Commissioner. I've been in that position since the end of June of 2020, so I'm fairly new. Thank you for asking me here to speak with you this morning. I'm not 100% sure what the committee is looking for, but from the motion that I was able to read, I understand the committee is interested in receiving an update on the work of our office, some information about any impact the COVID-19 pandemic has had on our office, and any challenges or opportunities with respect to freedom of information and protection of privacy. So I thought I might start with a brief overview of what our office does and what we're responsible for. I've met a couple of you I haven't met before, so I'm not sure how familiar you are with our office. So one thing that I have noticed since I started is that the Office of the Information Privacy Commissioner is often confused with the Access and Privacy Services Office, also known as APSO. But we're not the same. We're actually completely separate entities, and we're independent of one another. So APSO is a part of the Department of Justice and Public Safety and is a shared service within government to assist mostly government departments with their responsibilities under the Freedom of Information and Protection of Privacy Act. Our office, however, is an independent officer of the Legislative Assembly, which means that the role is not part of government or attached to any government department. We report directly to the Legislative Assembly, generally through the Legislative Management Committee, but it is directly to the Legislative Assembly itself. So the Information Privacy Commissioner has roles in relation to information access and protection of privacy under two pieces of legislation, the Freedom of Information and Protection of Privacy Act, which you'll hear referred to more generally as FOIP than anything else, and the Health Information, which sometimes is referred to HIA or HIA. So the primary focus of the Health Information Act, is the newer piece of legislation, is the protection of privacy, and more specifically the protection of personal health information, because personal health information is actually, if it's purely personal health information, is actually exempt from the FOIP Act. So it applies to custodians of personal health information, which may or may not be public bodies. Some entities are both, and those who manage information on behalf of those custodians, so information managers. It governs what personal health information a healthcare provider can collect, what that personal health information can be used for and by whom, and when it can and cannot be disclosed and to whom, and under what conditions. It also provides individuals with the mechanism to ensure that they have access to their own personal health information, which is in the custody of a healthcare provider or a custodian, and a mechanism to request corrections to their personal health information. So the FOIP Act, on the other hand, is only applicable to public bodies, such as government departments, provincial crown corporations and agencies, and certain municipalities and post-secondary institutions. And they are specifically designated in the legislation itself and the regulations. It has two main focuses. One is the protection of privacy and personal information, but it's also the freedom of information or access to records which are held by these government agencies. The privacy provisions are aimed at regulating the collection, use, and disclosure of personal information by public bodies and ensuring the security of the information that is being collected and held by these public bodies. The access provisions are aimed at providing an open and transparent government, ensuring public bodies are accountable to the public, and also allowing individuals access to their own personal information, which is in the custody or under the control of a public body, much like the health information for custodians. So there must be a balance that's struck between the desire for an open and transparent government and the protection of privacy of individuals. And that's what the FOIP Act does. It gives people the right to request records of information held by public bodies, subject to certain limit and specific exceptions, which are all set out in the legislation. But it also creates a right of access to those and creates a right of access to the records, but it also protects their personal privacy and the personal information that those government bodies hold. It also allows the individuals the right to access that personal information that's held by the public bodies. like the Health Information Act, people also have the right to request corrections of the personal information that's held. So what it does is it provides a mechanism for independent review of the decisions made by public bodies in relation to access to records or the protection of the personal privacy of the individuals and the information that's held within their custody and control. And this is where our office comes in. So one thing that should be noted is that our office does not process requests for access to records under FOIP or requests for access to personal health information under the Health Information Act. We don't provide any records directly to any person who asks for information or access to their information as well. That's all done by the public body or the custodian that holds that information. So what our office does is that we provide independent oversight over the public bodies who are subject to the FOIP and over the health information custodians who are subject to the Health Information Act. There are approximately 120 public bodies under the FOIP Act, subject to the FOIP Act, which we have the authority over. And these are comprised of every provincial government department office, the Premier's office, and the Executive Council, approximately 88 other provincial government agencies, commissions, boards, and crown corporations who are designated as public bodies under the regulations of FOIP, and 7 local public bodies who came in under FOIP approximately 2 years ago. In addition, our office oversees the information and privacy practices of all bodies and health professionals who meet the definition of being health information custodians, personal health information custodians under the Health Information Act. Can't tell you how many of those there are because they're just too many to count. It would include Health PEI is one, the largest one probably, I would think. They are a dual reporting entity. They are also a public body under the FOIP Act. But it also includes all regulated health professions, such as physicians, chiropractors, physiotherapists, occupational therapists, nursing, any of the regulated health professions. Any body or any other group that collects personal health information for the purposes of planning for health services or the provision of health services is considered a custodian. I'm not sure how long it would ever take to try and count them all, but there's a lot. So as I mentioned, there are some entities who are both public bodies under FOIP and health information custodians under the Health Information Act, and those public bodies actually have to, they have responsibilities under both pieces of legislation and are required to follow all of the requirements of both pieces of legislation. So we do a lot of other stuff, not just independent reviews. So in addition to conducting independent reviews of decisions, what our office does is the Commissioner is an independent oversight to ensure public bodies and health information custodians are following the rules around things such as appropriate security and safeguarding of personal information and personal health information, the appropriate use, collection, and disclosure of personal information and personal health information, and ensuring access to records in the custody and control of the public body or the health information custodian. We also have responsibility for reviewing privacy breaches and reviewing and commenting on privacy impact assessments, both of which are mandatory for health information custodians under Health Information Act, but are voluntary under the FOIP Act, but we strongly encourage people to actually the public bodies to do privacy impact assessments and voluntary breach reporting, and they are actually doing that. There are quite a number of public bodies who have been submitting privacy impact assessments for new initiatives or consulting with us on new initiatives. And also we've had a number of voluntary reports of privacy breaches from public bodies, which we encourage because it helps with accountability, transparency, and also positive change forward. So we have also a mandate of public education. So we not only educate the public on their rights to privacy and their rights to access to information, we also assist public bodies and healthcare custodians in understanding what their responsibilities are under the legislation as well. Just as an example, healthcare custodians have had a mandatory requirement to do PIAs since the Health Information Act was proclaimed in July of 2017. But what we've noticed is there's been a lot of changes in healthcare practices and provision of services, particularly since the pandemic started, and we're not getting as many privacy impact assessments in for review as we would have expected, given the number of changes that are being made. And what we found was that a lot of the healthcare custodians, not the public ones such as Health PEI, they're really good at the PIAs and they know what they're supposed to be doing, but a lot of the private healthcare custodians were not as aware of their responsibility to conduct privacy impact assessments and submit them to their office as perhaps we would have expected them to be. So we've undertaken a campaign to provide information to their regulatory bodies and educate them on what those responsibilities are and how to comply with them and those sorts of things. So we've had some uptake on that as well. Our office is largely complaint-driven. So there are some instances in our office where we can get involved on our own initiative, but our involvement more often starts as the result of a complaint. It could be a privacy complaint under one of the pieces of legislation, either FOIP or the HIA, or it could be as a result of a request for review of a decision of a public body or healthcare custodian, or it can be as a result of a complaint about a breach of privacy or a privacy practice of a healthcare health information custodian or a public body. So we also provide advice and guidance to public bodies on both an informal and a formal level. I think the biggest one formally is the one that was in the news recently, where the Department of Agriculture and Land had requested formal advice and a report, which we provided. That was actually the first one in 20 years of FOIP being around. That was the first time that we could find where we'd actually been requested to do a formal investigation or a formal advice and report. Most of our advice and guidance is more informal, email, pick up the phone, what do you think? This is what we're thinking about. Can you give us some information, some guidance, that sort of thing? And that happens quite often, and we encourage that. We also review legislation and answer questions from the public, and as I said, provide education on access to information and privacy issues, and we also participate in federal, provincial, and territorial information and privacy commissioners groups. We haven't had any in-person meetings that way lately, but we've had a lot of conference calls and video conferences, and we discuss a lot of different issues that are of importance right across the country. Things like certain things that we've discussed lately are the move to police forces using body cams, for instance, biometrics, using things like scanning of fingerprints. One that's come up in the last number of months since the pandemic is scanning of biometrics for the purposes of temperature, digital temperature readings, and those being not only done but also kept by companies sometimes for obviously for public health reasons, but there's also a lot of concerns around the privacy issues with those. So I wasn't in this position when the pandemic started, but I understand there were some challenges with in our office. One of the biggest challenges we faced were the physical space in our office. We're at the Jangus McLean building across the street, so it's an older building. Doesn't have a lot of space and a lot of options for moving things around. We were able to move our offices around and rearrange things so that we had more space and we were able to social distance more. We did have to stop meeting with members of the public. We used to allow members of the public, if they wanted to just drop in, ask questions, drop in and drop off access to our review request, those sorts of things. We've had to stop doing that. We don't actually have a space to meet with. We don't have a meeting room, we don't have a conference room, and we don't have any space within our offices really that it's big enough to meet with someone. So we've had to move to largely phone and online. One of the things we did when I started in the summer was we instituted a public email so that the public could find us very easily. It's on our website, and they can now file their reviews, because all reviews have to be requested in writing, and it used to be either through mail, regular mail, or drop-off. So we changed to an email address, and we can file people can file requests for reviews and privacy complaints and those sorts of things through email now. The other thing that we did not have was the ability to work remotely. We had desktops in our offices. They were quite old, but they were large desktops. We had one fairly ancient laptop, which actually stopped functioning not too long into the pandemic. While it was functioning, it was being passed around and people were using it, one person a day. And what we ended up doing was having one person come into the office and do rotations, one person in a day to answer the phones, use the computer, have access to our files. Because the VPN wouldn't work on the laptop either, so we didn't have VPN access to our network. So in the summer, we put in a request for upgraded technology, and over the summer and into the fall, we were provided with laptops for all three of us. There are three of us in our office, so we all were given laptops. So our desktops were replaced. The laptops were loaded with VPN, which worked. So we are actually now able to work remotely if we need to. And we're able to access our files and access emails and everything we need to do, so we can work remotely, which was a workaround. It actually improved, I think, our services in the office. We're more accessible now than we had been previously, which is great. So although the pandemic did present some challenges in the beginning, I think that we have adapted well, and I think that we've had some opportunity for, it's actually provided us with opportunity for improvement for our service in our office, which we're really pleased with. The other thing that we found with the pandemic was that we had a large increase in calls from the public, particularly around privacy issues, and we had the most volume of calls, I believe, in the early summer when the travel restrictions were in place and there were applications required to come to PEI, and there was a large volume of information that was being collected by the Chief Public Health Office and by public safety officials. And people were concerned about the authority to collect the information, the amount of information that was being collected, and the kinds of information that was being collected. So we did do a lot of back and forth with the public bodies on the information, and there was some information that was probably a little bit more than was necessary. So when we pointed that out, they very quickly made changes to that. And we don't have any issues with the information that has been being collected by the Chief Public Health Office or upon entry by the public safety and transportation officials at the bridge or the airport, those sorts of things. And I think they're doing a lot, and they have done a lot to ensure that they only collect the information that's absolutely necessary for the purpose for which they're collecting it, and only the information that they have the authority to collect under the legislation. Under the Public Health Act, the Chief Public Health Office does have an increased authority to request and collect information that they wouldn't normally necessarily have because of the public health emergency, the state of public health emergency. And the officials that were collecting information at points of entry also had an increased authority to collect certain information because of the state of public emergency that was in place at the time. So we did have a lot of calls and a lot of interaction with the public on those, but we did do some investigation, but we were satisfied that the public bodies were doing everything they needed to do around ensuring they were collecting the information and that they were keeping it safe and secure. And any recommendations we did make that they did accept and comply with, so we were really pleased at that. So what we're doing right now, I don't have any stats for February yet about what's happening in our office because we do our stats at the end of every month, and we do actually publish them and post them online on our website, so on a monthly basis. We're in the midst of doing our annual report right now for 2020. We do it on a calendar year basis, so we haven't completed that yet. But what I can say is as of the end of January, we had 55 open review files under FOIP, 6 open voluntary breach report files, and 8 open ongoing Health Information Act files. I'm not sure how many privacy impact assessments we're reviewing right now. We just actually got a number in the last few weeks, but we do have a number of those as well. In the past few months, we've also provided review and feedback on approximately 12 different pieces of legislation and policies for public bodies, some review and feedback and assistance on some access to information bylaws with a local public body. And we've been providing ongoing consultation with new government initiatives. One of those examples would be the new digital government strategy. So that group has had us involved all along, and when they have regular meetings, they also involve our office, and I actually attend a lot of the meetings as a resource to the committee so that they are looking at their responsibilities for access to information and protection of privacy and safety and security of personal data that's being collected and held by government right from the very beginning, which is something we encourage. It's a lot easier to plan and have that in as part of the planning in advance than it is to try and make changes later on down the road or even after something's been instituted and you find that perhaps there's been a mistake made or something needs to be done differently. So it's a lot easier to have us involved in the beginning, as early as possible, and we find that the government bodies are starting to do that, so we do encourage that. We do have a bit of a backlog of orders in our office, but it's actually not too bad. Our files date back, some of our orders that are outstanding date back to 2019. I have to credit former Commissioner Rowe. She did a fantastic job of trying to clear some of the backlog before her commission ended. And as a result, we are actually under what appears to be the general average nationally of approximately 3 to 4 years of backlog. Unfortunately, it's not unusual to have a backlog in orders and investigations, but we're actually not doing too badly, and we are putting plans in place to not only address the backlog, but also to try and keep up with more current files so that we don't get more of a backlog, and that we can clean up some of the backlog as soon as possible. So one of the things that did add to it a little bit was that as our responsibilities are being added to with new legislation, new public bodies, and also increased load with people who are seeking more reviews because people are getting more and more comfortable with what their access to information rights and protection of privacy rights are, and are questioning more what the decisions are. We do have an increased load, a little bit of requests for reviews. So what we're trying to do is to not only clear up the backlog, but stay ahead of the cases that we're getting in. What we haven't had any increased resources in our office at this point. So with the pandemic, it's been a little bit difficult to make any sort of assessments about what increased resources might be required, but so we haven't requested any resource changes at this point. I'm also very new. When we put our, when we did our budget for the upcoming fiscal year, I was only in the office for about not quite 4 months at the time. So in the middle of a pandemic and being very new in the office, it was something that was very difficult for me to assess. But that's something that we're doing on an ongoing basis, assessing what resources we have, what we can do better and more efficiently with those resources, and if there's looking at if there's anything else that might assist with that as well. So I'm not sure if I have answered your questions. There are a few other little things that we're doing. Just since I've started, we have started doing a little bit different reporting. We had not been reporting or tracking. We've been tracking but not reporting voluntary breach reports for those entities that didn't have to, it wasn't a mandatory reporting for privacy breaches, but we have noticed that there are more entities that are voluntarily reporting those with a view to assisting them with better processes. So we have started reporting those publicly as of January. The other thing that we have done is We are looking at redesigning our website, making it more user-friendly, and putting more information on it that would be more useful for people seeking services of our office, or even just answering general questions on access to information and protection of privacy for the general public. Putting more resources on there for public bodies and health information custodians for when they're dealing with members of the public requests, and also when they're dealing with our office if there's been a request for a review or protection or privacy breach. There are certain procedures for them to follow, so we're putting those in a more easily, we're working on making a more easily accessible format and having that posted on our website. And we're also looking at doing a policy and procedures manual of sorts for our office for reviews, not for the actual processing of requests, because that's done by the public bodies, but for reviews that can be used by both public bodies and applicants requesting review. And in January, we also issued our inaugural office newsletter. It got posted to our website. It didn't get widely distributed. We don't even have a name yet. It's just something we are looking at, thinking would be making our office more accessible and information more publicly available as well. So I'm not really sure if there's anything else that the committee is looking for, if I've answered your questions, but I'm certainly, I'll answer any other questions you have to the best of my abilities.
Trish?
Thank you, Chair, and thank you so much for this presentation. That was really informative. Good to learn about the work of your office in more details. I learned a lot, actually, in this presentation. You mentioned that that calls were up regarding privacy issues during COVID. At the same time as you were having this, like very basic technology, issue of sharing one, wonky laptop that wasn't really working properly. So can you just elaborate a bit more on sort of what impact all of those factors have had on your work?
Well, the calls, we did, as I said, we did try to have one person in the office. Even when we were supposed to be working remotely, we did have one person in the office. So we weren't around other people, so we were trying to do it safely so that we could actually have someone to answer phone calls and also check the voicemail. We can check the voicemail remotely. So that did take up quite a bit of time, but we assigned people to, there were, my understanding, because I wasn't there at the time, was that whoever was in the office was responsible for answering calls. And if it was the admin person, she would transfer those calls or have to one of the other individuals, the commissioner or the adjudicator, to answer those questions, or people would be called back. And we did have a lot that came in through email once we had our email up and running as well. That was over the summer. So it does take away from being able to do other work, file work, paperwork, those sorts of things, the administrative stuff as well as the adjudicative work. But we're very happy to answer those questions, because those are very important questions and things that people do need to know.
Trish?
One other, just sort of a specific topic that you brought up around privacy that, I've actually had some sort of questions about myself, so maybe we can elaborate a bit just around the digital temperature readings. So you mentioned that was one issue, or concern, I guess, that has come up around, when those can be gathered and how that info is kept and, and all of that sort of, those details that go around that. So can you just tell us a little bit about how that works then and what those rules are?
Well, some of the concerns that were brought up were primarily employers. We don't have authority over private businesses, but we do provide people with some information around their rights and obligations in those areas. So with the digital temperature, what we were finding, the main concern was that often it would be, like I said, employers would be either using a digital thermometer, the ones that you point at the forehead, to take a temperature reading. And there was one call where the person was concerned because their employer had apparently been using a scanner rather than just the digital readout from the handheld thermometer. And there are some legitimate public health concerns to be checking people's temperatures, especially in the middle of the pandemic and the public health emergency. But the biggest issue is what the collectors do. Is it just you have a readout, your temperature is a normal temperature and it's gone? Does it get kept on the device? If it's kept on the device, what is the procedure to get rid of it? Because do you have a reason to keep it? In most cases, I would suggest that there is no reason to keep those types of things. So ideally, they wouldn't be kept at all. It would just be a one and done where the readout comes up, you're good, go on with your day, and there's nothing recorded at all. If something does get recorded, there needs to be some policies in place where that information is not used for anything other than what it's recorded for. So other than recording the temperature to ensure someone's safe to come into work, or if someone has an elevated temperature, redirecting them to a health service for example, getting a COVID test. That should not be used for any other purpose. And ideally, it should not be kept beyond really that day, or if there's a really good reason, a couple of days for record keeping, but they shouldn't be kept for really any reason at all. So those are the types of things that we would be concerned about, is if you were collecting biometric information like the digital readings, temperature readings, if the entity was using them for other purposes. I'm not sure what other purpose you might use a temperature reading for, but there are other sometimes the biometric, especially if it's a biometric scanner rather than just solely a digital thermometer, there may be other readings that are being recorded, maybe inadvertently. So those are types of things that we would be encouraging companies or public bodies, entities to be looking at to make sure that that's not happening.
Trish?
That's all for now, Chair. Thank you.
Perfect. Michelle?
Thank you, Chair. Commissioner, nice to see you. I apologize for my tardiness, but because of technology, I was actually able to listen to your presentation, so which was great. So you talked a lot about how you had given advice to the Chief Public Health Office. I've heard from a number of people, so there's lists that are kept at restaurants, coffee shops, all that kind of stuff, and it has names and people's phone numbers on it, and generally you can walk into pretty much anyone and you can see that information. Did you have any advice on that and how establishments should be treating people's information?
Well, just for clarification, most of our contact was through the APSO office, so we would provide the advice and guidance to the APSO office. Any questions we had, we'd give to the APSO office, and they would make the inquiries and relay the information back to us, and same with any recommendations that we had. We generally make them through the APSO office because of the Central Privacy Services Office for the government departments. So there were questions about that, and I'm not sure you were here when I mentioned it, but we don't have authority over private businesses like restaurants and other establishments like that. So we didn't really have a lot of interaction with the Chief Public Health Office on that aspect of it, but we did, because we did have some public inquiries about that, we did look at the authority of the Chief Public Health Office to require that, and they do have the authority to issue directives, and my understanding is the Chief Public Office has issued a directive through under the Public Health Act, because of the public health emergency, for private establishments that are open to the public to keep names and contact numbers. We do provide some recommendations, things like the information shouldn't be kept more than is necessary. The Chief Public Health Office, I believe, had issued a recommendation of 30 days, which is not unreasonable because of contact tracing and the 2 weeks or so of contact tracing that they would have to go through. So that's not an unreasonable requirement. We also recommend that it be kept in a secure location and also kept not in view of the public. One of the things that we had recommended was that for restaurants, for example, if there's a hostess or a host, that they have control over it and that they write the person's name and contact information down, so that's not visible basically by anyone coming in behind them. Not all of the establishments do follow that practice. As I said, we don't have the authority to change that. We can just give the recommendations, and for anyone who's asked, those are the types of recommendations we've given.
Michelle?
Appreciate that. Thank you. Because often when you go into an establishment, it's not maintained that way. It's out for the public to see. Yes, yeah, exactly. Okay. I wanted to talk a little bit about what kinds of reviews you're seeing coming into your office. And so can you, I know you, for the special committee on government record retention, you kind of talked about what reviews and based on different complaints, so for instance, deemed refusal and that kind of thing. But can you just give us a brief overview of what the areas that you would do most of your reviews on?
Okay, sure. There are a number of different reasons for a review to go forward. There are third-party reviews. So if a public body has an access to information request and there's information about a third-party business, they are required to assess whether or not the information is subject to a mandatory non-disclosure under the FOIP Act, which is Section 15, and there's a number of criteria that would require the information not to be disclosed. So once a public body makes a determination if the information is a disclosable piece of information, then they are required to notify the third party that they are considering giving access to that information. And the third party has 20 days to either consent to the release of the information or to provide argument to the public body as to why they think the information should not be released. And to do that, they should be showing how their information meets a three-part test set out under the legislation under Section 14. If the government entity, the public body then decides that no, that three-part test is not met, so we are required to give disclosure, then the third party does have the ability to make a request for our office to review the decision of the public body to release the information. The information doesn't get released at that point until the review is completed. We actually have an increasing number of those happening, and we could have one access to information request and have 5 or more, several different third parties. We had one that came in last month. It was 5 actually, I believe 5 different third parties who had requested reviews. So we opened one file on that because it's one access to information request, but there are really 5 reviews under that. So when I actually talk about having 55 open FOIP request, FOIP review files, it's not necessarily just one review that's going on within those. It could be a number of them. Primarily, third parties are the only ones that have multiple reviews under one file. So we do quite a number of those. The other, we have requests for review in relation to adequate search and assistance provided to, so public bodies are required under the legislation to assist an applicant in figuring out what the information is that they're actually looking for. And they also have a responsibility, a duty to conduct an adequate search. So we do have quite a number of our reviews based on adequate search and assistance of the public body. We do have requests for review to ensure that information that's being redacted is in fact personal information or other information that is subject to mandatory non-disclosure provision. There aren't a lot of them in the Act, but there are some that are pretty clear. Personal information is one, cabinet confidence is one, legal privilege, like solicitor-client privilege, or litigation privilege is another one. That one actually does, the solicitor-client privilege and litigation privilege does provide us with a little bit of challenge because those records aren't provided to our office, so we do have a little bit of difficulty with that. With all of the other requests for review, the information that is provided to the applicant is provided to our office, as well as a copy of the information that may have been subject to an exception to disclosure, except for the legal privilege information. So we review to ensure that when a public body has decided that a piece of information is subject to a mandatory disclosure, that they've made that assessment accurately. The other area that we get request for review is something that we call a deemed refusal. So a public body can outright refuse to give information in cases like a mandatory non-disclosure, so they can refuse disclosure for that. But when we talk about deemed refusal, what happens there is it's a situation where the public body has not responded to an applicant within the time required by the Act. So under FOIP, a public body is required to respond to an applicant's request within 30 days, unless there's an assessment of a fee for mostly for certain and photocopying, and that usually happens when there's either a very long time frame or an enormous amount of records that are required to be searched. And in those cases, there's a fee estimate that's provided, and a deposit has to be put down before the search starts. So in those cases, the time kind of gets put on hold in those cases. But generally, in any other case, a public body has 30 days to respond to an applicant. In some cases, there are some situations, circumstances where they can, on their own, can extend for another 30 days, and those reasons are set out in the legislation. In other cases, in order to go beyond the 30 days or beyond the 60 days, they need to have the permission of our office to respond in excess of those time periods. So for a deemed refusal, the public body has not responded within either the time set out in the legislation or responded within the time that we have, the extended time that our office has permitted them the extra time to respond within. So basically, they just haven't responded. And there's no records, often there's no communication at all. What we find is the public bodies, if they're not going to meet the time, they do try to work with the applicants and often they will be able to negotiate extended time frames and those sorts of things. We do get requests for review when an applicant has just simply not had a response at all from a public body. So those are the ones most often done.
Sure.
Okay, that's fair. Thank you. So for the deemed refusals, have you been seeing an increase in deemed refusals?
I can only speak for the time that I have been in the office, because deemed refusals weren't actually tracked as a separate piece of information. They were all, it was just a request for review, and all requests for reviews were kind of lumped in together, not separated out. I did notice around August that I did see an increase in requests for review. Now, I have to say, I don't know how many deemed refusals there may be out there. The only ones that our office is aware of are the ones that people have come to our office and sought a review of. So I can only speak to what our office has in it, and I can only speak to my experience in the last few months. So I did notice in around August that I was seeing what I thought were a number of deemed refusals that I thought it seemed to be increasing. So I did start tracking them, and we really didn't start tracking them formally until till January, and the only reason I did that was because between Christmas and the second week of January and we were closed for a week in there, we received 3 requests for review based on deemed refusals in that time period. Since August, we've received 8. I can't speak to whether that's an increase or not. It was an increase over from the time I had started at the end of June. That's all I can really give you that information about.
Michelle?
And thank you, Chair. And from your knowledge of those deemed refusals, was there a negotiation attempt to change the timeline of the allotted time allowed, so go past the initial 30 days, or did it just expire at the 30 days?
In those ones that I'm aware of, I am not aware of any negotiations for extended time period. There may have been one, but the majority of them were simply the time had expired and the public body had not requested an extension of time from our office.
Okay, thank you.
Michelle?
And thanks, Chair. And so in January, how many did you receive?
We received 2 in fairly rapid succession in January. I think there were only 2 in January. There might have been 3. But it was, like I said, they were in rapid succession, and they were in the first couple of weeks of January. So that's what caused me a little bit of concern was seeing them come close together.
Michelle?
Thanks, Chair. And so when you receive a review, how much time does it usually take in order for you to correspond to the person who has asked for the review? And is there any change or delays there that you've experienced from outside issues, for instance, additional workload that your department, that your office is getting to, which I'll get to in a second, but.
It really depends on the circumstance. When we receive a request for a review, we try to turn around within a couple of days. The initial, we usually notify the public body the same day or the next day and it may be by email where we notify the APSO office. And then we try to send out formal correspondence to both the applicant and the public body within a couple of days. Sometimes it gets delayed a little bit, but most of the time it's either the same day or the next within a day, where we actually make the what we do is we first request the records from the public body. So we have to give them some time to get those together because they have to not only give us the records that were provided. So public bodies are supposed to keep a record of what they actually provided to the applicant. So we get that as well as the original records with all of the unredacted portions. So we give them some time to provide us with that, and then we have a look at that. We seek submissions from the applicant, which we send to the public body. Then we give the public body the opportunity to provide their own submissions. And we send those to the applicant, and the applicant is given the opportunity to give a reply. And if there's new information that's brought up by the applicant, then we also give the public body an opportunity to respond one more time. It depends, it varies whether there's new information that pops up in a reply from an applicant or not. So, but we do have to give time. Public bodies, they have more resources than applicants, so we tend to give the applicants a little bit more time. We give them a little bit more leeway, and it really is their review. So if they're seeking more time, we do try to accommodate that. Before you came in, I had mentioned we do have a lag time of about 2 years from the beginning to where a deliberation takes place. It can take anywhere from 3 to 4 months to, if things get delayed because of backlog, it can take up to a year or more to get a decision. We have recently made a few little changes. We've made some priorities, like deemed refusals. We are now going to treat on a priority basis because in those cases, the applicants just aren't getting a response and didn't get access to information. In other cases, they got access to information, just not all the information necessarily they were looking for. So we do consider the deemed refusals to be more of a priority. So we have put those on priority for shorter time periods for requesting responses and for turnaround as well. But there isn't a set time. We are supposed to be doing, under the legislation, it does look for a decision of the commissioner within 60 days, I believe. But that's in order to give the parties the opportunity to provide their information, provide their submissions. 60 days really isn't feasible. So there is also an ability under the Act to extend that time in circumstances that warranted. So most of the time it does get extended because 60 days to have submissions, replies, and further submissions is not, when you have public bodies that have numbers of submissions they have to do at a time, giving them a week or 2 weeks to do the submissions really isn't. It's not fair, it's not feasible, and it's not fair to the applicants either because they don't get full consideration.
Michelle?
Thank you, Chair. So I just wanted to shift gears for a second. So you recently did a review and provided advice at a request from government or from a public body on a report. Is that something that the office has ever done before?
No, that was the first one that we were able to find in our records that was ever requested and done.
Okay. And can you share what the resource allocation was to that review?
We didn't track resources in the sense that we spent this number of hours. We were doing it along with other work, but my time was spent substantially on that file. There was a period of time of about 4 weeks between the request being made and information. We requested certain information to be provided to us, so there's approximately 4 weeks. So the request was made in October, I believe, and the end of October, and we requested some information which was received the end of November, 1st of December. So between the 1st of December and the time when the report was issued, my time was spent substantially on that one file. There were other things that I had to do. There were video conferences, meetings, and some other file work, but I wasn't able to do any of the adjudication functions outside of that one because it was very intensive.
Michelle?
Thank you, Chair, and thanks for that. And my understanding, there's 3 of you in the office, is that correct? So,
yes, there's myself as commissioner, there is an adjudicator, and we have an admin officer.
Michelle?
thanks, Chair. And so when your resources are taken up, there's one other person doing, I guess, resource that's investigating or working on that. How does that impact the rest of the backlog that you've got in your office? Is it fair to say approximately a month of your time was taken up with that report? Okay.
It does have an impact, most definitely. When you have 2 people working on files and then you have to go down to 1, it does substantially impact the ability for output.
Michelle?
Thanks, Chair. And so I'm going to ask your opinion on this. This is the first time that a report of this type, that your office has been asked for advice. Is this advice that could have been provided at the APSO office?
I have a difficulty answering that question. The APSO office is very experienced. They and very knowledgeable. Whether it was information that could have been provided by the APSO office really is up to the public body. The public body does not have to use the APSO office, and they do have the right and the authority under the legislation to request it directly from our office. I don't know what their reason was for going to us, so I don't think that I can answer that question. Does the APSO office have the ability to answer questions about access to information? Yes, they do, very much so. They're very experienced, and I think, I'm comfortable with their ability to answer questions. Was it the question, did they have the ability to answer the questions the public body had? I don't know, because I don't know whether they actually went through APSO or directly to our office.
Michelle?
Thank you, Chair. So, do you have concerns if additional reports of this nature go through your office for advice?
If they were to become a regular occurrence, it would definitely be an impact on our resources and our ability to do our work. Because it's the first one since the legislation was proclaimed approximately 20 years ago, I don't know whether that's something that's going to be an issue or not. Earlier on, before you had arrived, I had mentioned that we do provide quite a bit of advice and guidance to public bodies, just on a more informal basis, and we're quite happy to do that. As long as public bodies are happy to, and it serves them well to have that advice and guidance provided informally. I'm not sure how often we would actually have the formal requirements or the formal report requests.
Michelle?
Thank you. And I know you had talked about your budget resources and your request, and you didn't actually ask for more resources in this budget submission. Knowing what you know now, and that you could receive a report at any given time, and precedent has been set to do that, would you be concerned with your current resourcing? Like if you could have it reassessed after this one, would you have done that? Am I putting you in a tricky question?
I'm not sure I can answer that one fully. I've only been in the position for about 7 months now. When the budget went in, it was pre the report request, and it was also I was only in the position for 4 months, and it's also, we're in the middle of a pandemic, which makes things different. So would I be concerned with the resourcing we have now if it were to become a regular occurrence? Yes, I would. And if I had information that was going to happen, I would have possibly made a request for more resourcing, but I don't think I can answer that definitively one way or the other with the information that I have right now.
That's fair. No, thank you for that, and sorry if I put you in a difficult position there. So just on the dates that were provided in the review, in the advice that you provided, so there was a dispute on dates. Can you elaborate, because then there was a change to the dates. Can you kind of clear that up as to what the information issue there was?
Yes, it was a mistaken date that was provided to me by the public body when they provided their, so under the legislation, the public body provides the relevant pertinent facts, and we had requested them to do that in writing, and when they did that, they had made a mistake on one date, the date that they had received the actual copy of the report. And so when we didn't realize there was a discrepancy in the date, so when I did the report, I used that date that was provided, and the day after the report was released, I was contacted by the public body and advised that they had made a mistake on the date that the report was released. It did not have a material change. It didn't make a material change to my advice in any way. So I simply made an amendment to the report, and I posted the amendment with an explanation as to the fact that there was a date that was recorded in error. It had been provided in error, and it didn't change my advice in any way.
Michelle, we have 5 minutes.
Oh, sorry. Okay, one last question then. My understanding is that you had provided the advice to the public body in advance of it being made public, for them to be able to review it prior to, and then they made the advice public. No, you made, sorry.
I think it was made.
Sure, no problem. Comments?
I'm sorry, sure. We did provide the advice, the report to the public body in advance of it being posted for them to be able to review it. And some of the advice we gave was to process a FOIP request that they had received in relation to the report. So we were giving them opportunity to have a look at that and if they had any questions and that sort of thing. And we actually do that. We were planning on posting the report. We just gave them the opportunity to have a look at that and to try and, do what they needed to do with the FOIP request. What we normally do for any review even, we will send out the order to the applicant and the public body and give them an opportunity to review it and ask any questions before we do post it publicly. All of our orders are posted publicly, and we do have a delay just to give them any chance to request any clarifications or that sort of thing.
Question. I appreciate, Chair, for you being so generous. My final question, there was no indication from the public body, though, once they received the advice from you, that there was any discrepancy with any of the information that was in the advice. It wasn't until after it was made public that was identified. Is that correct?
Honestly, I can't recall when that happened. I know that we posted it earlier than we had initially intended because the public body didn't have any other questions and they were okay with it being published earlier. So we did post it earlier than usual. And I'm not sure if the public body had realized there was an incorrect date at that point. So I don't know when they realized the date, but the posting happened, I think, on a Monday or Tuesday, and it was the following morning that they contacted me and said that there was a discrepancy in the date. I don't know when they were aware of that.
Right, but they had received it the week prior, on the Thursday or Friday prior.
I believe so. I can't recall for sure, but I believe so.
Okay, thank you very much for coming in, and Chair, thank you very much. Appreciate it.
Great. Just on behalf of the committee, we'd like to thank you for coming. Oh, sorry, I didn't see it. Sorry, Corey, go ahead.
I didn't raise my hand.
Okay, go ahead.
Thanks, Denise. Thanks for your presentation. There's a lot of talk about the report that Michelle's referencing, and in your report, was it you said it should go through the FOIP process to be released? Is that, or can the minister just say, no, here's the report, we're going to make it public? I guess, how does that work? Is that just something they can do, or does it have to go through the FOIP process, or?
In this, it depends on the circumstances and it depends on the information. In this particular case, the minister had hoped to I believe in his public statements he had hoped to release it proactively. However, there was a lot of information in it that could potentially have been subject to some mandatory non-disclosure under the legislation. So what my recommendation was to review the report for any potential mandatory disclosure information or mandatory non-disclosure information. And make a decision based on that. There just happened to have been a FOIP request or more than one FOIP request at the time. So that was really, and FOIP requests didn't get put on hold for that. They still had the requirement to respond to the FOIP requests. So my recommendation was to process the FOIP requests, and because it was required under the legislation, and in so doing, they would automatically have to do the review for whether there was any information that was subject to mandatory non-disclosure.
Corey?
And then once the department went through that process, they could release it.
I'm sorry.
So once the department went through that process, they could release it, the
Yes.
report?
Yes, I believe
Even without a FOIP request,
that was a possibility. I don't know if that was something that they had considered. I'm not sure. I worked on the information that I had, and the information that I was provided was that there actually was a FOIP request already made at that point.
Corey?
And for your office budget, does that go through Legislative Management Committee?
It does, yes.
It does, okay. Perfect.
Corey?
That's not good, thanks, Chair. I know you're at the
School committee, okay? Okay, well, thanks a lot for coming in. I think it was a good hour spent. I'd like to, we'll just take a short break. We'll give our guests a chance to switch over. There's another presenter here ready to go. So thank you very much.
Thank you.
Great. Okay, we're back for the second part of our morning session. Committee members, I have to leave. Can I get consent from the committee? I have an event or something in my district. Is it okay that I appoint Hannah Bell as the acting chair for the remainder of the portion of the meeting? Is that okay? Perfect. Okay, so I'll appoint Hannah. Come on up, take the chair. Thank you, committee. Might have messed that up.
Your target's just kind of about that one. We're all about the formalities here. Yeah. Yeah, while the chair is gone. All right. So, welcome back to the Standing Committee on Health and Social Development. We're now in the second part of this morning's agenda, item number 4, and we're here to have a briefing with Acting Director of Privacy Services, Justice and Public Safety, Clare Henderson. So, welcome.
Good morning.
Do you have a presentation for us?
I do. In fact, I have a PowerPoint presentation
Oh,
today.
wow, all the bells and whistles. Okay, so perhaps would you like to do your presentation and we'll hold questions till the end? Would that work?
If that's agreeable.
Does that work for the committee? Okay, let's do that.
So I thought I would give a little bit of an overview of how the Access to Privacy Services Office works and the work that office does within the Department of Justice and Public Safety. So the office was actually established in 2014. APSO was created to allow for the efficient and timely processing of access to information requests. But one of the things that it's important to know, as you would have heard from the Commissioner's presentation, the number and volume of public bodies that are covered by the Freedom of Information and Protection of Personal Privacy Act are significant. And APSO does not assist with the processing of all requests for all public bodies covered by the Act. And so you'll see that APSO provides support and assistance and processing for the Department of Agriculture and Land, Economic Growth, Tourism and Culture, Education and Lifelong Learning, Energy, Environment, Energy and Climate Action, the Executive Council Office, the Department of Finance, the Department of Fisheries and Communities, the Department of Health and Wellness, Justice and Public Safety and the Attorney General, the Office of the Premier, the Department of Social Development and Housing, and the Department of Transportation and Infrastructure. And so all of the requests for information that come in through the APSO office would relate to these specific departments. APSO does not support health PEI, elections PEI, the public school branch, the Fathers of Confederation Buildings Trust, the French Language School Board, the Island Regulatory and Appeals Commission, the Island Waste Management Corporation, the Office of the Police Commissioner, the PEI Human Rights Commission, the PEI Liquor Control Commission, the PEI Cannabis Corporation, the Workers' Compensation and Appeals Tribunal, or the Workers' Compensation Board. Now, if you were to go to APSO's website on princeedwardisland.ca, we actually provide a list of contacts for each of those individual public bodies, so that if an individual is coming to APSO thinking that we're a one-stop shop for absolutely everybody, they can be directed to the appropriate resource for having those access requests made and processed. So to talk a little bit about how the office is structured, the APSO office has a full-time manager position who also acts as a full-time FOIA analyst. We, in addition to the manager position, have 3 full-time FOIA analysts, and those are the individuals who work with applicants and public bodies to process. Yep.
Just to interrupt. FOIA is the Freedom of Information?
Yes.
Thank you.
To process the information requests. So the Freedom of Information analysts are the individuals applicants who are requesting information would be dealing with once their application is assigned. The office also has a legal counsel who provides legal advice directly to the APSO office and to public bodies. And so I thought it might be helpful if we go through exactly what happens when somebody wants to make a FOIP request. So, and at the same time, I'll talk a little bit about how COVID impacted the operations of APSO. So one of the what we would call a COVID plus is that in advance, even before COVID, APSO had an online application form that people could fill out to make an access to information request. So that means you can go on the FOIP website and fill out a request and pay the fee, and that request is sent directly to APSO for processing. So the way the office works is each of the FOIA analysts are assigned a particular department. And so, for example, if a access to information request comes in for education, that would come to a particular FOIA analyst. And so once the FOIA analyst receives the request, they review the request and determine what process needs to happen. So it's who in the public body do they contact, where do the records live, where in the department, because as you're aware, departments are not always small. Some of the departments have multiple divisions. And so, for example, when a request comes in for the Department of Public Safety, Justice and Public Safety, it could fall within any number of areas of the very large department. And so the FOIA analyst coordinates with the public body. They also coordinate with the applicant, because sometimes the applicant will make a request, but it's very broad and it's not necessarily clear about what information the applicant wants. And so the FOIA analyst, as part of the obligation that the commissioner talked about in terms of a duty to assist, the FOIA analyst actually also works with the applicant to make sure that the applicant is clear about what exactly they're requesting. And so while coordinating with the applicant, the FOIA analyst also coordinates with the public body and provides the public body with recommendations or advice on what specific exceptions may apply under the Act. And as the commissioner noted, there's two distinct pieces of legislation that apply to information in the province. There's the Freedom of Information and Personal Protection Act, but there's also the Health Information Act. And APSO does not provide advice or assistance. We're not involved with the Health Information Act process. And so sometimes someone will make an access to information request under FOIP to, for example, the Department of Health and Wellness. But really what they're asking about is their own personal health information. And that falls under the Health Information Act. And they have to deal with the health information people within health PEI rather than health and wellness. And it's important to understand that one of the reasons why the office was centralized was so that it became a single point of entry for FOIP requests. The FOIA analysts that work in APSO are exceedingly familiar with the operations of the department and the complexities of making access requests, right? And we found that almost 99% of the requests for information that come in through our online submission service. And they come in from a variety of sources. So we get requests from individuals who are making personal requests about their own information. We get requests from the media. We get requests from law firms. We also get requests from academia, which we are seeing more of right now because we are in what people constantly refer to as a unprecedented global pandemic. And so researchers and academics are very interested in things that are going on and how people are responding. We get requests from businesses. We get requests from political parties and other organizations. And so once that request comes in, APSO works with the public body to ensure that the public body understands how to engage with a reasonable search for records. APSO from time to time does training with employees and public bodies on how to do a reasonable record search, because much like a lot of life, things can get complicated. We live and work in an environment where there's multiple things going on. We've got people who have emails, we've got people who have paper records, we have people who are now, because of the pandemic, working from home. Right? So the other important thing to remember is that APSO is a processing service. We provide information and support and guidance, recommendations, but ultimately the responsibilities under FOIP fall to the public bodies. It is a public body's decision what ultimately they decide to do with the records, and it is their decision about what the appropriate application of the exceptions are. And so, APSO, while we provide advice and support, the responsibility for engaging in the search, and so going through and locating all of the records that may respond to a particular request, that's the responsibility of the public body. APSO will then, all of the records are provided to APSO, will review all of the records and make recommendations about whether or not there may be particular exceptions, either mandatory or discretionary, that apply. But the final decision that's made about whether or not records can be released rests with the head of the public body. And so there's sometimes a misunderstanding by the public that it's APSO's decision about whether or not information gets released. But ultimately, it is the public body that has to comply with FOIP. It is the public body whose responsibility it is to ensure that they're protecting the personal information of the individuals and organizations that are found within the responsive records for a search. And so, you would have heard the Privacy Commissioner talking about how there has to be a balance between the wish and the wish by everybody to be transparent, but also protecting the privacy of the individuals who engage with government. Members of the public don't necessarily always have a choice about the personal information that they're providing to government services. If they want to receive services, they have to provide information to us. And it's a public body's obligation to ensure that they're complying with the legislation when they're deciding what records can be released. And it is complicated. One of the things that happens in terms of the process is when a request is received by APSO, APSO creates a file, the public body engages in the search for records, and APSO reviews those records with the public bodies and identifies for the public bodies what the process considerations are. And so if a record comes in, we have an obligation under the Act to consult with third parties. And third parties are individuals who are not the applicant and not the public body. And so if there is a reference to a business or another person or another level of government, right? So if there's information provided by the federal government or a municipality, we are obligated under the Act to consult, because that is not our information. And there are often things to consider that we would not be aware of in terms of other people's information. And while the public body may wish to release the information, we have a duty to consult with the third party so that they can take a position on whether or not they want their information released in the context of the FOIP request. And that process, by times, is not always quick, particularly during a pandemic, when third parties like governments, even private businesses, are operating in a different fashion than they once were. At the height of the pandemic, when the world in very many ways shut down, our mechanisms for contacting individuals who were working in other locations didn't always work. There were times when you would contact somebody in a different government or a business, and you would leave a message, and whereas before they would have picked up the phone because they were sitting in their office, right? And so APSO was very fortunate when the pandemic hit, because APSO, the FOIA analysts where we're located, many of the FOIA analysts have their own office, and so we were able to comply with physical distancing recommendations. We were also able to secure laptops so that a number of the FOIA analysts could work from home. And so, but the thing to remember is that it's not the FOIA analysts who have to engage in the search. And not only were government and business, like private business operations, impacted by the pandemic because people were complying with public health restrictions and working from home or not currently working, the individuals within the public bodies who would be engaging in the search were also working from home without access to necessarily their offices or their records. And that's not just the truth for public bodies within Prince Edward Island. That's the truth for third parties that we continue to consult with. I think it's important to remember how fortunate we are in PEI currently, because our daily life, because of Islanders' compliance with public health restrictions, looks different, but in many ways more the same as it used to be than other parts of this country that are in lockdown. And so when a FOIA analyst is trying to engage in the consultation process that's required under the Act, particularly when those consultations are happening outside of Prince Edward Island, they're very much impacted by the pandemic. There's also the reality that government operations continue to have to address public health realities that change. Sometimes it feels like on an almost daily basis. And so when a FOIP request comes in and we have requests for public bodies that are trying to pivot and shift and provide the services that they continue to provide to the public, they have to do the search on top of the necessary and sometimes urgent work that they're doing to provide services to the public. So ideally, the search for records and the review, the processing of those records happens within 30 days. But particularly in the time of COVID, it is not always ideal. One of the other realities is that the FOIP process is not the only work that the FOIA analysts engage in. FOIA analysts also provide support to government on privacy issues, and so we support the investigation of privacy breaches. The FOIA office, the APSO office facilitates privacy impact assessments to evaluate FOIP compliance with FOIP and HIA. And the APSO office provides education on privacy obligations under the FOIP Act. The APSO office is also the centralized point for all of the public bodies that I listed at the beginning of the presentation for consultations, because it's also important to remember that PEI is not the only province that has privacy legislation. And so just as though when we receive a request for records, we have an obligation to consult with third parties, the government of Prince Edward Island is also consulted as a third party by other levels of government and other jurisdictions. And so if another province gets a FOIP request that may have information that relates to a public body in PEI, they have the same obligation to consult with us as we do to them. And those consultations happen through the APSO office for the public bodies at the beginning of the list. You'll also note that because public bodies within government and established under the Act are required to consult with each other. And so when a request for records comes in and one department or one public body may have information that relates to another public body, they have to consult with each other. So we, the APSO office, consults with other levels of government, like the provincial and federal government and municipal governments that are now provincially covered under the Freedom of Information legislation. So if you were to look at the number of FOIA requests that are received by the APSO office, you will see that it's difficult to establish a trend. It will be interesting to see where the final bar graph is at the end of this year, because we've seen an increase in the number of requests coming into the office since January. And so we saw it between 16 and 17, a trend where there were a very large number of requests received, and it appears to be slowly trending up.
Can I sorry,
Yep.
just interrupt for a moment, just because I don't think we can see the numbers clearly on those ones. So,
Oh, sorry.
yeah,
So,
on the bars, yeah.
so in 16-17, there were 327 requests received. In 17-18, there were 215. In 18-19, there were 240. And in 19-20, there were 264. And so thus far, in this fiscal, there's been 214. And I can tell you that number has probably changed since I hit print on this presentation.
So that's only to December 31st. You've
Yeah.
still got the remaining quarter
Yes.
to go. Okay. Is that? Okay. I think we're okay. Thank you.
Okay. So if you were to look at the trends in the APSO office, we're seeing more requests. I can tell you that as of yesterday, APSO had opened 83 files. If you were to look at the same period last year, we had 48 requests. Much of the increase can probably be attributed to COVID-related requests. Obviously, COVID generates a lot of people wanting more information. But one of the trends that we have seen and continue to see is that the number of pages being located, the number of responsive records being found is up. And so, whereas a single request previously may have seen 5 or 10 pages worth of records, we're now seeing hundreds, if not thousands of pages. And ultimately, that means a longer time to process those requests, because each of those individual pages have to be reviewed and processed. And so, and in terms of some of the administrative realities of coordinating that search when you have a huge volume of pages that are coming in, those pages have to be processed through the system that APSO uses. Each of those have to be identified. If there are, when the decision is made by the public body about the release or non-release of that information, if some of the information needs to be redacted, all of that has to be processed. And so, we're seeing more complex requests for information coming in. And so the processing time is increasing as the volume of responsive records comes in. We're also seeing more interaction with the Health Information Act. More of the time we are getting requests that somehow intersect with HIA, and so parts of the responsive records may relate to information under the Freedom of Information and Protection of Personal Privacy Act, but they may also contain health information which would be covered under the Health Information Act, which also adds to the complexity of the processing. So this is a breakdown of the types of requests that have come in. You'll see that there's the vast majority of the information that requests come in from individuals. So it's one person who decides that they're going to make an access request. We also see a volume of requests from the media. And we even receive FOIP requests from political parties. We see an upward trend this year of requests from academics and from lawyers and law firms. So in terms of completion time, you'll see that in 2021, requests for records were granted in full or in part, 61% of the requests. So 61% of the time, the ultimate decision made on the file was to release some or part of the records. 39% of the requests that came into the office were actually answered in 30 days. 24 requests were answered within 60 days, and 31% of the requests were answered in over 60 days. We've also seen so far in 2021 that 8% of requests so far have been sent for review to the Privacy Commissioner's office. This is actually down from 50% of the requests in 1920. So we've seen a decrease so far in the number of files that are being, where either the applicant or the third party is requesting a review of the decision or action by the public body. So this is probably more helpful. So this is actually a breakdown of the number of requests received by public bodies. Now, you'll see that the list is a little bit longer because it goes back to 2018-19, which is when some of the departments had different names. Mm-hmm. And so you'll see that, there's been a number of requests received. You'll also see that some departments engage with the FOIP process more often than others. And whereas APSA would be dealing on a regular basis with some of the departments, not all of the departments are often subject to FOIP requests, which is one of the benefits of having the centralized APSA office. Because sometimes there will be employees in government who will, throughout their entire career, never be asked to engage in a search for records to respond to a FOIP request.
Will you be able to share your presentation
Certainly.
digitally afterwards? Yeah, so we'll get the numbers sent out. I saw a colleague there trying to take a picture of the screen, so I think it might be easier if we can just have it emailed out afterwards. Sorry to interrupt, but yeah.
Always thrilled to share stats.
Okay, so we'll make sure every member of the committee gets a copy afterwards. Great. Thanks for this.
Pie charts make our hearts aflutter.
Yes, there we go.
So this just talks about the other work that the APSO office does. And so the Privacy Commissioner talked about the voluntary reporting that happens through the public bodies about privacy breaches. And so that's actually a fairly large part of what the APSO office does. So from time to time, there can be kind of inadvertent releases of information in ways that government departments may not intend. The APSO office is the point of contact for the public bodies in government to get advice and assistance on how to deal with privacy breaches. And APSO consults regularly with the Privacy Commissioner's office about the response that public bodies engage in if there is a privacy breach. You'll see that on that list, it also talks about consults, and so this is a list of the number of times that APSO is contacted by other levels of government or other public bodies about consulting on information requests that are received through processes outside of the province or in other public bodies. And this just gives you a bit of a graphical representation of the FOIA requests this year in the past 3 quarters. Again, doesn't include the 83 requests that we've talked about that we've received so far as of yesterday. So that would be the end of the presentation.
Great. Thank you very much. So I said lots of data and numbers, and we'll get that sent out. But I think I have Michelle on the list. So Michelle,
Thank you. And thank you, Claire, for being here today. I recognize how bad my vision is because I can't even come close to focusing in on those numbers, so you'll have to bear with me. I took some pictures so I could zoom in so I could actually read it, but thank you for that. So you went over how many FOIP requests you've received. Is there any particular department that you're seeing an increase, or any public body that you're seeing an increase of year over year? Or is it fairly random?
It's a tough question to answer because it honestly, the requests that come in depend on what's happening in the province, and so I don't know that there would necessarily be a rhyme or reason as to why one department may see more requests than another. We've seen over the past number of years, a what I'll call a frequent flyer in the FOIP world would be transportation and infrastructure, right? People are interested in what's happening in that department. I think also that the information and data that we're going to see is going to be a little skewed because of the pandemic. We're seeing more very broad requests come in for information about how government is dealing with the pandemic, and that, as I said, APSO processes requests from academics and other organizations that are interested in like a large volume of data. I find it interesting because you look back at, I read all of these interesting articles and newspaper reports from the Spanish flu pandemic in 1918. And all of the information that was gathered about how that process went. And then you think, well, this is 2021, and we have computers and emails and internet, and imagine all of the information that needs to be compiled to look at that. And so I guess the long answer to your short question is, not sure.
Michelle?
Thank you, Chair. But it looks like we're increasing, especially after what you said about yesterday. You've opened several yesterday. Can you what's your resourcing like in the APSO office to be able to manage that?
So like I said, we have 3 full-time positions in the APSO office. Again, understanding that APSO provides support to that list of public bodies and not all the public bodies, and so I don't mean to suggest that the APSO office is the only resourcing that's provided to access to information requests, right? Because there's that fairly comprehensive list of other groups that APSO does not support. But we have 3 full-time FOIA analysts and the manager position, who also has a caseload of APSO files, and the solicitor. I can tell you that we are very hands-on with the staff about what their workload is and what the operational requirements of the office are. And I'm constantly discussing with the department, and they're constantly checking in about whether or not more resources are needed. I'm comfortable right now, but let's be honest, didn't really anticipate that there was going to be a pandemic that might impact staffing resources. And as the pandemic evolves and as processes change, it may be that more resources are required. But if that's the case, government is very committed to supporting this process.
Michelle?
Thank you, Chair. So when you reference there's a whole list that you do not support, the numbers you provided us, though, do not include those.
Exactly.
Except for Health PEI, I see is in here, in this list. But do you...
So the Department of Health and Wellness, which is separate from Health PEI. So the way I like to think about it is that the Department of Health and Wellness is the administrative governmental support. Health PEI are the people that work at the hospitals and engage with the health information, your doctors, your nurses, all of that. And that's a great point, because when the privacy commissioner is talking about reviews that go to her office, they're not just from files that are processed by APSO, right? And so there cannot. It's easy to make the assumption that all of the information in the privacy commissioner's report would directly correlate to APSO, but that would not be correct.
Right. Michelle?
And thank you for clearing that, but the numbers that you provided are actually the ones that APSO reviews. So I'm going to just come back to that in a second. A couple other things I'm wondering about. Have you experienced difficulties with any of the public bodies? Like, is there any specifically that are not responding in the allotted time?
So again, the process in terms of APSO's role is to provide information, support, and advice. I think it's fair to say that government is very committed to this process, but the reality of a FOIP request, particularly when you're talking about thousands of pages of information, that search process, the reasonable search process that the commissioner referenced, is something that happens on top of the daily operational duties of the staff who may have what we would call responsive records. And so, APSO is always looking at ways that we can support public bodies in engaging in that process, and we're currently undertaking a bit of a review in the office if there's additional things that we can do to support public bodies and being able to position them to respond within the timelines under the legislation. Right? Certainly that has been impacted by some of the operational realities of the pandemic. It's also important to note that our obligation to consult under the legislation with third parties and with other organizations, APSO, the public body, and APSO are required to comply with those processes. And so, for example, we're not permitted under the Act to disclose information from the federal government without their consent. And so, particularly in areas of the country that are harder hit by the pandemic than PEI is, the response times on some of those consults take a long time. But it's always our hope to be able to be transparent with information. And so, do I think that we can do better? I think we can always do better, and I think that's a necessary part. That's a necessary approach to how APSO and the public bodies function, because looking at how the requests are being processed and how public bodies are responding, that's how we grow and evolve and improve.
Michelle?
Thank you, Chair. And so I think my question was more along the line of, so you collect the information. You don't go out to the public body, search the records. Somebody within the public body does all of that and you collect the records. I guess my question's more around sending second requests, sending follow-up requests, that kind of thing from the APSO office, not the actual gathering of the records yourself, but actually, like herding people to actually provide you with the records. Do you find, have you identified within that function of gathering that there are departments that are slower to provide information than others, public bodies?
I don't know that we have, and I don't know that is information that we track. One of the challenges is that the request for information can vary so greatly in terms of complexity, and so sometimes you're not always comparing apples to apples, right? So one person can make a FOIP request and they're asking for one document, and so a search request, and some of the departments, for example, have information that's requested frequently. And so they're in a position to have that information available and prepared because it's a frequent request. And so I don't know that that's information that we track, and I don't know how we could necessarily accurately reflect that information given the complexity. Like we have one request that resulted in tens of thousands of pages of documents, right? Like that's not 5 minutes to do that search. And so it's certainly something we could consider.
Michelle?
Okay, thank you. You referenced different types of requesters, and you actually identified it as political parties and media, etc. And you've referenced frequent flyers. How is that information gathered, and who has access to that information? So from that perspective, does the provincial government track that information or tie it to individual FOIP requests?
So just a mild correction. When I said frequent flyer, I was actually referring to TIE. Transportation infrastructure. Transportation infrastructure gets a number of requests because people are interested in some of the information. So I wasn't referring to an individual requester or a type. The kind of breakdown of the sources of the information request is something that's tracked by APSO. It's not. Really, it makes no difference to APSO who's requesting the information. We have a process under the Act, and that process is followed whether or not it's Clare Henderson making the request or Peter Mansbridge, although that would be fun, just to talk to him in real life. I know, right? Lovely human being. But it
podcast.
literally makes no difference in terms of how the how the request is processed. We track the information because it's information that's discussed at a kind of national level to see where the sources of the requests are coming from. It's just a kind of interesting informational tidbit.
I'm going to go to somebody else and then come back to you if you have any further questions. Heath?
Just curious on your 83 requests since January, is there a common theme there for the entity that they're requesting FOIP from?
The trend that we're seeing is that the volume of requests seem to be COVID related, but we don't. Again, from an APSO perspective, we don't necessarily track what the nature of the request is, because it can vary so much. I think it would be challenging to put boxes around the type of information that's being requested. But certainly our view of the trend is that it's COVID related.
Heath?
And are you seeing a large increase in extensions requested or refusals given?
We've had to ask for more extensions, particularly over COVID, just because of the operational challenges within the public bodies, particularly during the height of the pandemic. One of the roles that I realized I didn't talk about is that APSO liaises with the applicant about like timelines for responding and things like that. And so I don't know that we have I don't know that we're tracking the number of extensions, but certainly the response time is impacted by the fact that we're dealing with a change in operations because of COVID.
Heath?
So, are you tracking refusals?
Again, that's information that we currently don't track, but it's certainly something we can look at. Again, sometimes one of the things that can happen is a person who requests information, an applicant, can also abandon their request. And so if APSO is liaising with an applicant who makes a request that we are attempting to process, that request, there's a processing issue. If the applicant doesn't respond, we, after a certain period of time, would not continue processing the request. We would consider it abandoned. But technically, the clock runs from when the person makes the request. And so, again, as with much of the law, it's complicated. sometimes.
Heath?
Curious, Claire, and there's many departments and one minister's responsible for both. And there's been obviously the controversy on the land use, whatever, recently. Would it make more sense to have a single minister of justice as opposed to a minister of justice in, say, tourism, or a minister of justice in agriculture as it is? Or like, would it make your job much easier to have a single minister and responsible for FOIP for one instance, but there may be others, just because you oversee basically all the legal entities of government?
So I apologize, are you talking about the allocation of ministerial portfolios generally or for FOIP purposes?
Well, combined. How does that, is there any effect there, or could it be better utilized, I guess, is what I'm trying to say.
Well, I can tell you that the primary point of contact for the FOI analysts and for the processing of FOIP requests would be with the deputy minister, and so all of the ministerial portfolios in government would have their own deputy minister or assistant or associate deputy minister assigned to the portfolio. We have a number of ministers who have multiple portfolios, but certainly, the deputy ministers that we engage with and the ministers are interested, briefed, and well informed about the process. I don't know that I could comment on the decision of government to allocate portfolios. It's certainly not unusual, particularly in small provinces. I would wonder if they'd have to make this room a little bigger if they tried to change it.
Yeah. Trish?
Thank you, Chair. So I think you mentioned that sometimes a public body abandons their requests, or if you are seeking clarification and they don't respond. Sorry, an applicant, my mistake. So can you tell me a little bit about when that request would be considered abandoned?
I don't have that information specifically, so ABSO has a comprehensive process and that they use for providing assistance on advice. Our act, as you may be aware, is modeled after the Alberta legislation, and so we work quite closely with the Alberta, with the kind of comparable work section in Alberta, but I'd have to get more information on that. Ultimately, at any point in the procedure, an applicant can withdraw their request, right? And certainly, always our approach is to, in aligning with our duty to assist under the legislation. Ultimately, our approach is to contact, prompt, notify that, we would, if you do not respond, we will consider the request abandoned and things like that. So, we're not hearing from somebody in 2 days and then saying, oh, well, you've abandoned it. But, and I'm not suggesting that it's a frequent occurrence, but it certainly is something that happens from time to time. Sometimes because people get information from other areas, right? And so they may make a FOIP request and then, be provided the information through another source, right?
Trish?
Thank you, Chair. Yeah, no, and you answered my question there. I guess I wanted to make sure that the applicants were being informed that if they didn't respond, then it would be abandoned, because you wouldn't, of course, we wouldn't want anybody to not realize.
Excellent, and they're in frequent contact with the applicant, and as the commissioner noted, they're consulting with the Privacy Commissioner's office on process and things like that.
Trish?
Thank you. So one of the things I've, wondered about and heard concerns, from constituents would be around the fees associated with FOIP requests, and that might sometimes be a barrier or deterrent to filing a FOIP request. I wonder if you could speak a little bit about the necessity of fees, or if there has been any discussion, or if there's the possibility of removing the fees for FOIPs and removing those barriers.
So one of the realities of the fees under the FOIP Act is that those fees can be waived. And often when information requests come in, if it is perceived or the office is advised that $5 fee is a barrier for the individual in making the request, there's the authority to waive the fee. The fee is something that we frequently discuss, but currently, the part of the reason why the fee exists is to hopefully provide somebody with an opportunity for considering if they actually need to make the request. I say that because sometimes when somebody's making a request under FOIP, there's information that they can get from directly engaging with a government department outside of the Act, if the information isn't subject to the mandatory provisions under the legislation, particularly if it's an individual requesting their own information, right? The process for engaging in the search, engaging with APSO, is administratively intensive for the APSO office, and we have effectively 4 FOIA analysts, and so we've done some viewing of other jurisdictions who saw that removing the fee, which for many people would not be a barrier to the process. Again, it's $5. That a blanket removal of the fee resulted in an inundation of the office on people just kind of blanket firing off FOIP requests. And when those requests are received, we have to process them. And so I would suggest that, particularly given the ability for the fee to be waived, it's about balancing the administrative realities of the demands and encouraging people to engage with the information holder to get their own information without going through that process. So it's a bit of a balance. I understand the concerns, but I would encourage anybody who feels as though that fee is impeding their ability to make the request to engage with the APSO office for the public bodies that are under the APSO office. And there can be consideration that fee be waived for just such a circumstance.
Trish?
Okay, thank you. And just so I make sure that I understand how this works, so is it a $5 flat fee regardless of the size and scope of the request?
So there's two different processes under the Act. My apologies, I thought you were referring to the application fee. So in order to make a FOIP request, there's a $5 fee.
Did you have a question back here?
Okay, can we just keep the side chat to a minimum, please, so that people can focus on the questions and the answers from the guest at the floor? Thank you. You had a question, Trish?
Yeah, no, go ahead.
So there's an initial $5 processing fee. That's the fee that I thought you were referring to. So there are circumstances under the Act where a public body can evaluate the cost of engaging in the search for records, because sometimes and it's not all requests that engage in this process. Generally speaking, it would be the kind of larger requests that require significant resourcing to be able to process. And so, that fee is often done in consultation for the files that fall under APSO. APSO would be assisting the public body in determining what the resulting process would be for the processing of the request. But again, even in the event that an individual felt that if there was a public body imposing a fee, there is an opportunity for the individual to say that is a barrier for the request. And so, again, there's a process that's set out under the legislation for engaging in a discussion about what the costs of the search and the production of the records may be. And ultimately, the decision of the public body to engage with the cost component is a decision of the public body that's subject to review by the Privacy Commissioner. And so if there is somebody who's unsatisfied with the decision of a public body to engage with that piece of the legislation, or to decline in the circumstances to reconsider or waive the fee, that's one of the independent oversight functions that's held by the Privacy Commissioner.
Just one more quick question on that. So how often are requests to waive these fees submitted, and how often are they rejected and need to be perhaps reevaluated by the Privacy Commissioner?
That's not information that I have with me. I'm not certain whether or not that would be specific information that we track. I can tell you that it's not. Acknowledging that we just had a discussion about the changing trends in the size and volume of records, the majority of requests there wouldn't be a consideration of a fee beyond the initial application fee.
Okay.
For now, Chair.
Michelle?
Thank you, Chair. I'm just going to go back to abandoning, where you had said some applicants abandoned their request. I believe it was Commissioner Rose, when we were talking about the government record retention, made a comment that information, the age of the information is what's so important, right? So the older that the information is, the less value that information now has. And so I'm actually gonna go to social media, because when we were talking about this and about scheduling this meeting, there was somebody from the media had kind of written around his struggles with getting FOIP requests answered. And I'm just gonna read one into the record that says, most egregious so far was a request for briefing documents from the Premier's office filed February 4th, 2020. Received the documents September 28th after weeks of emailing and calling every contact I had in access and privacy services, with no one responding. I should probably FOIP what happened there. So when you have a case like that, and if you're not tracking measurements, or how do you know how well you're doing? Like, nothing against the staff. I know, like, everybody is trying to do their best, so nothing around that. But when you don't track measurements on the length of time that it takes to respond, it's fine if it's a 1,000-page FOIP request, document that. Mm-hmm. And then you know if it took 6 months, well, it was 1,000 pages, so yes. So how do you explain that kind of experience from somebody who's putting in a FOIP request?
So again, just a mild correction. You had asked if we were tracking the number of times that APSO was following up with departments. You'll note from the presentation that we actually track the amount of time that requests take to process. I had indicated, perhaps I can just go back to that slide. We do actually track the amount of time that requests take to process. And again, you know, we are engaged in a process within the office about seeing what, if any, steps we can do to better support and provide information to public bodies so that they can meet timelines and responses. Again, the ultimate reality of the Act is that it's the public body's obligation to perform the search and to make the decision about the release of records. And so I can speak to you about the work of APSO in supporting the public bodies. I can't speak to you about the decisions that are made by public bodies under the Act in relation to their obligations.
Michelle?
Thank you, Chair. I'm just going to point out, though, APSO is the entrance. Mm-hmm. You know, every FOIP request goes through there, and all of the follow-ups come through that office with the public body. And so if we're not tracking how many times we've had to request follow-ups with with public bodies, that just leads to an increase in the amount of time that people working in the APSO office are spending on very administrative, very mundane issues, that if there is something that's chronic there, by tracking how many times you've had to follow up and who's not responding, that then would allow the office to operate more efficiently. But it sounds like some people who put in applications, the onus is on them to do the follow-up with APSO because they haven't heard back and have asked multiple times. So is there any kind of tracking within the office where if you have problems and you've identified areas that you could create more efficiencies, is there tracking that's happening right now?
So again, I'm not aware that we're specifically tracking the amount of follow-up that the staff is doing. I am aware that they are following up, and it is my experience with APSO that, as I indicated, they're very available to applicants, but again, they're conveying information about the decisions and actions of public bodies. And so sometimes, there can be a perception, particularly a public perception, that it is APSO that is responsible for making the decisions and engaging in the search, right? We provide information, support, and recommendations to public bodies. I certainly hear what you're saying, and again, we are constantly reviewing what service APSO can provide in terms of supporting public bodies in the timely and efficient processing of requests. And so, as I indicated, we're currently engaged in a review of what, if anything, further we can be doing, and I certainly hear what you're saying.
Michelle?
Thank you, Chair. So in some situations where the public body hasn't responded, and I completely understand that APSO's not responding, and I'm hoping that my questions are coming across as it's the staff within that office. I'm just simply saying there are indications that the staff within that office needs more support in order to get the information that they're required to get. And so if they're not getting the information, that needs to be identified so that situations can be fixed, especially if responses are outside of the FOIP Act, in which they have 30 days to respond, the public body. I don't mean APSO, but APSO is the ones that have to deliver that message to the public. So you are the in-between person, which would seem that it would be the place to capture a whole lot of data that could possibly make the whole process more efficient for everybody involved. But there has been, I've been notified about some instances where the applicants are offered the opportunity to have their request completed outside of the FOIP process. How frequently does that happen?
Again, not information that I have with me, and I don't know that that's information that we track. And so, for example, if somebody was to make a FOIP request about information that is their own personal information, so if I engage with a government service and I want a copy of the information in my file, theoretically, that request doesn't have to happen through FOIP if I'm only seeking information that relates to me. And so, because the FOIP process is administrative heavy, often, the individuals are encouraged to get their own information if they can, and to work with public bodies outside of the Act, because the FOIP process may not be necessary for them to get that information. Sometimes people who make applications to the FOIP office don't necessarily understand that they're not required to go through FOIP to get their own personal information. And so, honestly, I don't know if that's information that we would be tracking, because generally, if the request is not truly is not necessarily one that has to be processed under FOIP. We would encourage people to, like the FOIA analysts often sometimes act as a bridge of information for that individual. I should also point out that, you know, the Act does allow for the extension of time for processing of requests. You know, you'll note on my very helpful slide that 39% of the requests received in the office were processed within the 30-day timeline, but there were times that extensions had to be granted. Again, there's such a variety of the types of information and the complexity of the information. It's not always reasonable for that request to be processed within 30 days, particularly when the type of information that's being requested intersects with so many different public bodies, right? So if I make a FOIP request and that FOIP request asks for information from like 15 different departments, or one department has a document that has information about different public bodies outside of the province, organizations, third parties, the processing is complex. And again, it's about having to balance our obligations to protect the privacy of individuals and our obligations towards third parties. And so it's not always an easy answer.
Michelle?
Thank you, Chair. So just to clarify, though, this was not a personal information request. This was a request from a frequent flyer that you've already mentioned. So again, giving that offer to applicants to do it outside of the FOIP request, I would suggest that might be information that probably should be tracked to see how often they're given that advice and why they're given that advice. But I would like to ask, or I'd like to understand, does this impair or affect the applicant's access to their rights under the Freedom of Information Act if they take up the offer of having it processed outside of the Freedom of Information process?
So again, just to clarify, at no point have I referred to any applicant as a frequent flyer. Again, I was referring to transportation, infrastructure, and energy.
But I was
Okay.
referring to that exact same public body. That's where the request went into.
Okay.
And so it went into transportation, infrastructure, and energy.
Okay.
So it wasn't in privacy. It wasn't access to personal information.
So if through the request to the APSO office, the applicant decides to proceed to get the information outside of the timelines, outside of the FOIP process, it would in no way impair their ability to re-engage with the FOIP process if the information provided to them was not to their satisfaction, or they had concerns that the disclosure was in violation of a particular provision of the Act. You'll remember, as the Privacy Commissioner discussed, one of the sections of the Act talks about the obligations of government in relation to privacy. And so, for example, if somebody was concerned that the information they received outside of the Act was offside of the privacy obligations of government, they would have the right to engage with the Privacy Commissioner's office and make a complaint, or discuss with APSO their concerns about any potential privacy breach. If they felt that they hadn't been provided all of the information that they thought perhaps was available, they could engage with the FOIP process and make a more formal request.
Michelle?
Thank you, Chair. Okay, I'm going to move to another topic completely. So can you provide us APSO's involvement in the IRAC land report release?
So as we went through, I'm going to flip back. So the Commissioner noted that a request was received through the FOIP process. That request is being processed by the FOIP office. Again, the obligations for public bodies in terms of compliance with the legislation and the law are significant. All requests are reviewed to ensure that any subsequent disclosure is considerate of any mandatory or discretionary access restrictions under the Act, and that process is in process.
Michelle?
Thank you, Chair. So did APSO provide advice to the minister?
So in terms of the APSO's providing advice, this request would be treated the same as any request that was received. The FOIA analyst would be engaging with the public body, providing information, support, and recommendations about what, if any, exceptions apply. In the event that there are third parties that need to be consulted in relation to the information that may be in a document that's requested, APSO would engage in that consultation.
Michelle?
Thank you, Chair. So was APSO requested to provide advice outside of the FOIP request prior to it going to the Information and Privacy Commissioner?
So remember, ultimately, the decisions about how a public body engages with FOIP fall to the public body. There are multiple avenues for a public body to receive advice, including the process that was followed. And so, the decisions made by public bodies about what processes they engage with, either processes through the APSO office or through the Freedom of Information and Protection of Personal Privacy legislation to seek recommendations from the Privacy Commissioner office, that's ultimately the decision of the public body.
Michelle?
Thank you, Chair. Did the public body seek advice from APSO?
The FOIP request was received, and the APSO office would be engaging with the public body with information, support, and advice.
Michelle?
I feel like we're going in circles. So did the public body, prior to the FOIP request and prior to sending it to the Information and Privacy Commissioner, ask APSO to provide any guidance or support on the report?
I'm not aware of the specific timelines, but my understanding is that the processes happened in a fairly timely fashion for both. And so, again, ultimately, the decisions about how the public body engages with the Act rests with the public body. I'm not certain what the specific timelines were, but again, APSO is responsible for responding to FOIP requests, and my understanding is the FOIP requests came in, as they often do, quite quickly. So I suppose the answer to your question is I don't know. APSO has provided advice in relation to the FOIP request.
Michelle?
Thank you, Chair. So in your opinion, which I consider to be a fairly expert opinion as to what APSO does APSO would APSO have the expertise to be able to provide advice to the minister on whether a report should be made public or not?
I don't know, to be honest, if it's a fair question. There's two processes available under the Act, and I don't know that I would suggest that it would be more or less appropriate to engage with APSO or the Office of the Information and Privacy Commissioner. The legislation provides the avenue of seeking advice. The public body relied on the legislation, and I certainly would never suggest that it would not be appropriate for a public body to engage with the law of the province and take a step to seek advice from the Privacy Commissioner office. I don't know that anybody questions the expertise or the valuable assistance that APSO provides government, but certainly the Act contemplates, allows for, and prescribes the ability of public bodies to engage with the Privacy Commissioner's office to seek recommendations. And I certainly would not wish to suggest that it would ever be inappropriate for a public body to seek to rely on the legislation of the province. And so is APSO, absolutely, are they awesome people that do great work? Absolutely they are. Would I suggest that it would be more or less appropriate? No. There's multiple avenues under the Act for public bodies to seek advice.
Thank you. One last question,
Sure.
Chair. So this was the first time it's ever happened to the Information and Privacy Commissioner as far back as they can tell. So who would, in a situation like this, provide a minister or a public body with advice on a report prior to it being made public?
I'm not in a position to speak to that. I certainly would not be able to speak to whether or not why this is the first time that piece of the Act has been engaged with. Certainly the public body in all instances would be obliged to consider how to best ensure the protection of information in the release of information held by government. You know, I wouldn't be in a position to speak to that.
Okay. Are there any further questions from the committee for the presenter? Do you have anything further to add for today? Okay. So on that thing, we'd like to thank you for presenting today, and we'll just take a very brief recess for you to be able to finish up, and then we'll close the meeting with any last business. Okay? And we're back. So that concludes the presentations for this morning. Is there any new business from committee to bring forward at this time? No? Okay. Oh, Trish?
I just wanted to follow up on something from last week. So when Dr. Amanda Hudson was presenting, she committed to providing the committee with the evaluation framework for the mobile mental health units, as well as information about the focus groups and consultations they did prior to deciding on the model. Did the committee receive any of that information?
Not yet, but I'll follow up.
Thank you.
Okay, that's great. Thank you. Okay, so I'll just remind committee that we're back this afternoon at 1:30. That will be a briefing on the decision for the participation in Atlantic Lottery Corporation's online casino. We'll be hearing from the Minister of Finance, the Honourable Darlene Compton, and the Department of Finance Manager of Policy Planning and Regulatory Affairs, Jennifer MacDonald-Donovan. So that's this afternoon. On that basis, if there's nothing else, then can I have a motion to adjourn? Zach Bell? Meeting is adjourned. Thanks.